right, welcome, ladies and gentlemen. This is Deshaun Bradley from the Fighting Carrier. Getting ready to get started with the latest update from Mr. Renfro here concerning our contract. We want to see how this is going to go, and we'll play it in its entirety when it starts in about 3 minutes. Hopefully I can actually show the screen here. I'm still working on learning how to use OBS Studio. If anyone has any tips or anything, please let me know, because I'm doing research and stuff. I mean, I'm 46 years old. I grew up, I'm Gen X, grew up with this technology, but at the same time, it's like, yeah. So, work in progress still, but should be starting here in a few minutes. And I'm going to get off here, and if you see things juggling up and down, that's just me trying to figure out how to get this on my screen. So with that said, I'm going to sit back, be quiet, and wait for Renfro to come on in about 2 minutes. So we shall see, and I will edit this a little bit too, delete some of this back and forth, up and down screen shots I've been doing, but hopefully this works and we're all able to see this today. Hopefully we hear something good, but I doubt. I know we're waiting by law for the 60 days to pass through. I know we got the convention coming up too. I was gonna try to go to it this year, but circumstances came up to where I won't be able to go. Hopefully I can go to the next one, as I'm considering, as I said, running once again, but we shall see what happens in the future. So right now he should be getting on in a few minutes here. So it's 8:01 right now. Oh, here it goes. Getting ready to start. Here we go.
Welcome to part 2 of our collective bargaining update. Last week I did a video of, I think we ran about 45 or 50 minutes where we talked about the status of the economic side of bargaining and went through all the proposals that the Postal Service had presented us in collective bargaining. That update was from a hotel on May 22nd, which was the day that our contract expired. In that video, I said we would have a second part to this update because of the sheer number of proposals. Didn't want to keep anyone too long, so here we are. This is part 2 of that update. As I mentioned, our contract expired at midnight on May the 22nd. It's really important to note and ensure that everyone understands that our 2023 collective bargaining agreement, though it expired Friday night, May 22nd at midnight, that agreement continues in full force and effect until we either agree upon and have a ratification vote to ratify a new agreement, or we achieve a new agreement through the interest arbitration process. So by law, after the expiration of the contract, if we are not in agreement, we have a 60-day period of mediation. So we are, as we sit here today, very early on in that period. We've got another almost 2 months of mediation. During that time, we're going to continue to negotiate and continue to, see what progress we can make in hopes of ultimately reaching a tentative agreement that we could send out to our members for ratification vote. One really important step in this process that I mentioned in the first video is that next week we have a collective bargaining conference where representatives from our branches and state associations all over the country are going to be in Washington, D.C. We look forward to having the opportunity to spend 2 full days with them to talk in depth about where we are in bargaining. We're going to talk a lot about interest arbitration, what the case looks like. We're really excited to get a lot of feedback from our branch and state leaders to help chart the course for what we will do in the next few weeks and coming months if we end up going to the interest arbitration process to resolve our differences. So for this video, I am going to cover the proposals that we, the union, NALC, has submitted. There are over 80 proposals. These are all proposals that were developed by subcommittees of our executive council members. Of course, they utilized a lot of different information. They reviewed our official bargaining positions, those that have been resolutions that have been submitted to our national conventions by state and states and state associations and branches that have been adopted by delegates to conventions. They have reviewed a lot of information in terms of polls and surveys that all of our members have participated in. We had 2 different rank and file committees, one last September, one this past January, that came in and spent a week to dig really deep into a lot of different topics. And our executive council members took each and every bit of information and input, put that together, and ultimately crafted these proposals. So while the final count is 80-something, there were far more original drafts of proposals. Many of them were on similar topics between one committee and another committee. While we divide each of the subcommittees up by topic, there's some just kind of natural carryover that happens. So some of them have been consolidated. For example, the very first one I'm going to talk about is about an MOU that different committees and sometimes even within the same committee had multiple ideas, and those things were consolidated into 80-something proposals. So it's a really long list. I will go through them as expeditiously as possible, but I do want to be sure that I explain them enough so that everyone that's tuned in here has an understanding of the things that we have submitted. Just a couple of notes. Number one, there are a number of these proposals that have to do with CCAs, making changes and improvements to contractual provisions that impact CCAs. Of course, our union's goal and something we have been pursuing in this round of bargaining is to eliminate that CCA category and get to an all-career workforce. But part of the preparation that we have to do in proposals is ensure that we are prepared and we have proposals ready for any scenario that we can envision. And while our preference and what we keep pursuing is certainly to eliminate the category altogether and have an all-career workforce, there's no question that it's a possibility that we might not achieve that completely. We may get part of the way there. We may have CCAs in our next agreement in some form or fashion. So therefore, these proposals were submitted and put on the record, and we continue to negotiate over them so that in the event we do still have some CCAs in our among the classes of employees in the letter care craft, we are able to hopefully achieve some of these improvements. The other is that these proposals have all been submitted, of course, in any round of negotiations for NALC or any other union. In history, there's never been a point in time where either management or the union submitted their proposals and the other side just said, we agree. There's also never been a time where the union or management in any round of bargaining has gotten agreement on every single one of their proposals. So as I go through them, there are certain ones that I might mention a little bit about the status of them, but many of them, as we are very early in this mediation period, are still under construction, so to speak. Negotiation is still happening. So, keep in mind, these are the things that we submitted. We've already spent a lot of time over the last few months since February bargaining over these proposals. A lot of that is going to continue, but I did think it was important to give all our members that tuned in here the opportunity to know and hear about each and every one of the proposals that we have officially submitted in collective bargaining. So with that, I'll jump right in. The first one is a proposal that would make 3 different changes to the MOU on bereavement leave. The first change is currently the bereavement leave MOU allows for 3 days of bereavement. This would expand it from 3 days to 5 days. That's the first change. The second change is it would expand the definition of family members that are covered by the bereavement MOU to domestic partners. And also it would expand the definition of family members to cover step parents, mother-in-law, and father-in-law. Next is paid parental leave. This is something that's really important to us. It would provide 12 weeks of paid family leave for the birth or care of a child. This is something that other federal employees have. That's been a goal of ours in multiple rounds of bargaining now, and it continues to be an important piece here. I mean, very simply put, FMLA coverage is there, but FMLA coverage only protects the employee. It does not guarantee a certain type of leave. You have to use the existing leave. Of course, for us, that's annual leave or sick leave. What this proposal would do is create a completely separate category of leave that could be used when you have the birth or adoption and subsequent care for a new child. The next is an MOU on leave sharing that will modify the leave sharing MOU to allow sick leave to be shared and also reduce some of the restrictions for donated leave. Next, an MOU that we submitted that would provide some protection on the Postal Service's use of technology and the data that comes from that, such as GPS. What this proposal would do is provide some protections by using similar language to the language we have in many past, primarily interpretive step settlements related to projection systems like DOAS and the office efficiency factor and so on. And that language would simply say that this GPS data or whatever other data from technology out there could not constitute the sole basis of discipline. The next one is a proposal to modify Article 16, Section 10. This is a section that deals with employee discipline records. Currently, employee discipline, absent a grievance decision otherwise, remains on file for 2 years. This proposal would reduce that 2 years to 1 year, and it would also require that at the end of that 1 year period, that discipline would automatically be removed from the employee file as opposed to the employee having to request that discipline be removed. Next is what would be a new MOU about a purge of letters of warning. This would basically say that any letters of warning that were issued within the 6-month period prior to the effective date of the 2026 national agreement would be purged and not cited in subsequent discipline. Another Article 16 proposal, this deals with Article 16, Section 6, which is the section about indefinite suspensions. These happen in crime situations, and this would place a limitation on the amount of time that a letter carrier could be in that status without pay. Effectively, what this proposal would do is change the language in Article 16, Section 6, so that after 30 days, the letter carrier would be placed on administrative leave. Next is one that'll be of interest certainly to our shop stewards out there. An Article 31 proposal, Article 31, Section 3, this deals with our right to information, and this is a proposal, the language change would require management to provide information that's requested by either the end of the tour for that steward, or if they're unable to do that, to explain the reasons why, and to provide a date when that information would be requested. Next, we'll move to Article 35. This is the article that establishes the Employee Assistance Program, or EAP. At the end of Section 1 in Article 35, there's a sentence about that those seeking treatment for alcohol or drug abuse would be, I think the term that's used without it right in front of me is, would receive favorable consideration in disciplinary matters, and this proposal would add mental health and other support programs. So this proposal would change that language to say those receiving treatment not only for alcohol abuse or drug abuse, those receiving treatment for mental health and other support programs. The fact that the letter carrier seeking that treatment would get favorable consideration in any grievance proceedings on or the issuance of discipline. Article 41, Section 3 is the next one. This is the craft article for the letter carrier craft. Section 3's got all sorts of, I guess you'd call them miscellaneous provisions that most of us are familiar with. And very simply, this proposal would grant an additional break to letter carriers that are working overtime. Next, also in Article 41, Section 3 is a proposal that would modify the current process for identifying lunch locations. So, we all have a PS Form 1564 that's in the route book that slides up under our case and where we identify lunch locations. This would just create more flexibility, really allowing us to take a lunch at any location as opposed to just those locations that were identified. Additionally, and this is one that has been a goal of ours for some time, is we have a 30-minute lunch. This proposal would exclude travel to and from the lunch location from that 30-minute lunch. So what we're proposing here is you would have whatever amount of time it took to travel to. Once you ended your travel to and arrived at the lunch location, your 30-minute lunch would begin. When your 30-minute lunch ended, then you would travel back to your route. Another Article 41, Section 3 proposal. This deals with Article 41, Section 3P, which is the language that requires the Postal Service to notify the branch president of any motor vehicle accidents. This would modify the language to extend that requirement for notification to not just motor vehicle accidents, but to all job-related accidents. So that the Postal Service would then, anytime an accident happened, regardless of whether it was a vehicle or some other type of accident, that the branch president would have to be notified. Next, we'll move to Article 17, Section 2, which covers a lot of the things that representationally for stewards and how many stewards and things like that. We'll start with Section 2A, and there's a ratio that's included in Section 2A that talks about how many stewards we can have. This would modify that ratio and base it on the number of NALC branches in a facility. So this is something that a long time ago we never had to deal with, but over the course of the last 15 plus years, whether it was the old DUO process, delivery unit optimization, or more recently, the Postal Service creating sorting and delivery centers. In a lot of locations now, we have letter carriers that work in a single facility, and we have multiple branches representing different groups of those letter carriers. And sometimes, frankly, those of you that are watching this that have been involved, or either a letter carrier in one of those facilities, or a branch officer, or someone that's active within one of the branches, it can create situations where we have to designate different branches to do different things, and this would just clear up the steward side of things. So each branch would be able to select their own steward, and the Postal Service would not just recognize that steward, but maybe more importantly, have the obligation to pay them as they do other stewards. Next is also in Article 17, Section 2. This will go to Section 2F. This proposal includes language that will require management to provide space in facilities for the union to conduct official business in private. A lot of our branches around the country have for a long time utilized space within the post office to conduct their union business. This is something that in some locations has become kind of a hot topic, and this is a proposal that would eliminate any issue and make it clear that the Postal Service would provide that space. Next is an MOU on annual leave carryover that would extend, or I guess permanently increase the amount of leave we can carry over from 440 hours to 520 hours from one leave year to another. For a number of years now, we have done a yearly agreement with the Postal Service to increase it from 440 to 520. This simply would make that a permanent increase. Next is one that's kind of related, or at least impacted by that annual leave carryover, and it's an MOU on monetization of annual leave. This was a new MOU in the 2023 agreement that allowed letter carriers to sell back some annual leave if they met certain conditions at the end of the year. Last year, when we did the MOU to increase the carryover from 440 to 520, we also modified that MOU to increase the amount of leave we could sell back from 40 hours to 80 hours. What this proposal would do would be to increase it permanently to 80 hours, and we also included in this proposal to remove the sick leave usage limit. So there's currently a limit on how much sick leave one can use and still sell back leave. Next, we'll go to the grievance arbitration procedure. I know on the previous video, if you tuned into that, I talked about a couple of Article 15 proposals that we had submitted, just because you had Postal Service proposals and then you had our proposals. And I'll kind of briefly touch on those when we get to them. But these are others' Article 15 proposals, not the ones I talked about earlier. The next couple here have to do with arbitration, which is in Article 15, Section 4A. The first proposal is in 4A10, and we have submitted language that would require procedural arguments and arguments on the merits to be heard the same day in arbitration. And let me just give a little bit of context and background there. So often when we take a grievance forward to arbitration, the Postal Service advocate will attempt to make some sort of procedural argument to challenge the term that we use is the arbitrability of the grievance. So, you know, they may argue that the grievance is not proper for whatever reason. It might be a time limit. It might be something they claim the union didn't do correctly. It might be that it's an issue that they believe shouldn't go through the grievance arbitration process. Sometimes they come up with stuff that is completely outlandish. Often what happens is they will make that argument. Sometimes the arbitrator will rule right then and there and say, you know, more times than not, dismiss their argument, say this grievance is properly before me, and then we move to the actual grievance, the merits of the grievance. It might be, you know, a discipline grievance where a letter carrier has been issued discipline and we're challenging that. It might be a contract grievance where management has violated the contract. What the Postal Service very often does is after they make that procedural argument, they will ask the arbitrator for something called bifurcation. And what bifurcating a hearing means is we hear the procedural arguments, they ask for bifurcation. If bifurcation is granted, then that means that we're not even going to hear the merits of the case that day, the actual grievance, we have to come back at a later time, schedule a new arbitration date to do that. Honestly, this is used by the Postal Service pretty often just as a tactic to delay grievances. Most of the time, we start arbitration hearings at 9 a.m. or thereabouts. We are supposed to have that arbitrator for up to 6 hours that day. These procedural arguments, most of the time, do not take very long. So all this is language saying that we will hear both of them, that takes away their ability to ask for this bifurcation just simply as a tactic to delay grievances. Also about arbitration in Article 15, Section 4A5, we have a proposal regarding witnesses. It's really simple. Basically, the proposal is that arbitration witnesses, letter carriers, where the hearing is scheduled outside of their normal work schedule, that they would be paid for the time that they spend testifying in an arbitration hearing. Next proposal is a letter of intent. It's also Article 15 related, talking about Step B impasses. So the Step B team gets a grievance locally, and there's 4 things they can do. They can resolve the case, which that's what we want them to do. Sometimes they can hold the case if there's maybe a national grievance that's pending on the same topic. They can remand the case, which we don't like to do very often, but there are circumstances where we should send the case back to the lower parties for more information. And then finally, they can impasse the case. And if they choose or they can't agree on the case, so it's an impasse, those are grievances that then go up to our National Business Agents Office. Our NBA could then appeal them to the arbitration process. This proposal has to do with the contents of the decision that the Step B team writes on an impasse. And what it would do is limit what the impasse decisions can cite to the evidence and arguments that is sent to them from the previous step, from formal Step A. In a nutshell, this removes the ability or even attempt for a team member at Step B, in our experience more often the management member, from at Step B trying to build the grievance. That is the responsibility of the local parties. Next, another Article 15 proposal. This is in Section 2, talking about informal Step A, which our shop stewards out there would be familiar with. This is, where we have the initial meeting on the grievance and initial off on the grievance form, the PS form 8190. And this language would require management to initial the 8190, without the union having to request it. That sometimes has become an issue. All right, let me get into a few CCA proposals. As I talked about in the beginning, our goal is an all-career workforce. However, we have to prepare for any possible outcome. And while our goal is a non-career workforce, it's certainly a possibility that we have a non-career. Our goal is an all-career workforce, certainly a possibility that we have a non-career workforce. So a number of these proposals are intended to improve things for our current non-career workforce, these city care assistants. The first is an MOU regarding Christmas pay that, in a nutshell, would allow CCAs and require CCAs to be paid Christmas premium for those that work on Christmas Day. Next has to do with holidays. Currently, CCAs receive some holidays. This is a proposal, a change to Article 11, Section 8, that would require CCAs to be paid for all 11 holidays, like career employees are, or full-time employees are. Next is a PTF proposal with Article 11. Currently, PTFs are not paid holiday leave, so they're not paid for the actual holiday, however, on that day, but they are paid for holidays. There's a formula there in Article 11 where PTFs, compared to full-time employees that are at the same step, are paid a higher hourly rate based on a calculation that's done that effectively spreads the pay for the 11 holidays across their straight time rate. This proposal would, without modifying that, we certainly want to continue for PTFs to receive that higher hourly rate, to have them be paid for the actual holidays, holiday leave, just as full-time employees are. Next, another one back to CCAs. This is about the CCA advanced annual leave. Currently, annual leave is advanced to CCAs at the end of their first term. This would change that and require 40 hours of annual leave to be advanced to CCAs upon the completion of their 90 workday or 120 calendar day period at the beginning of their appointment. A real simple proposal here, but an important one to do with Article 16. Very simply incorporate CCAs into Article 16 so that everything in Article 16 would apply to CCAs just as it does career employees. A little bit of history with that one. If we go back to the DAS award, the interest arbitration award that created the CCA category, it has something that we commonly call Appendix B. It had Appendix B that just laid out on all these different topics language that would apply to CCAs, and it had a discipline process and some protection related to Article 16. We have worked through multiple rounds of bargaining to strengthen and have to some degree strengthen those protections from discipline for our CCAs. This would take it all the way to provide the same protection for CCAs as Article 16 provides for all of our full-time employees. Another one to do with CCAs, Article 7, Section 3C. You would probably know this as the maximization language in the contract. It's been around for a long time, that currently includes part-time flexibles and them being converted. This proposal very simply would include CCAs just as it does PTFs in Article 7. A kind of simple proposal here to do with Appendix B that I mentioned a minute ago, which still resides in our contract. It's got a lot of provisions that cover different pieces for CCAs. One of those is health insurance. We've made some pretty significant improvements over the years to health insurance for CCAs, and there's some language that kind of remains from years past that's no longer relevant based on those improvements that we made. This proposal very simply in Section F of Appendix B would remove that outdated language. Okay, next, the full-time flexible MOU. The actual title is Maximization / Full-Time Flexible NALC. Currently, this, when certain work requirements are met, 8 hours a day, 5 days a week for 6 months, requires the creation of a full-time flexible job. It currently only applies in installations that are over 125 work years. The change that we propose here, number one, would add CCAs to the MOU, so they would be just like PTFs, and it would also apply this full-time flex MOU to every size office, not just those that are over 125 work years. Next, a kind of little discussed and frankly little used article. I would venture to say that for branches out there and kind of longtime stewards and contract enforcers, it's highly unlikely that you never filed a grievance about Article 4, which is the article about technological and mechanization changes. We have proposed in Article 4, Section 2, to add NALC to a committee that would have a semi-annual meeting with representatives from the Postal Service and include us in any sort of training or any other kind of technological or mechanization initiatives that the Postal Service may be undertaking. Honestly, this is something that we've participated in a lot over the years, so it's not a new concept. It would be new to be a requirement of the collective bargaining agreement, but it's something that over the years we've participated in quite a bit. Obviously, as technology continues to progress and grow, it's, I think, reasonable to conclude that it's going to become more and more important in the future as the Postal Service looks to continue to grow the technology they use, and just like the rest of the world, they have more ability now to incorporate technology than we've had in years past. Next is an Article 22 proposal about bulletin boards. Kind of goes back to the earlier proposal I mentioned about the Steward formula, where because of DUO and because of the creation of the SNDCs, we've got facilities now where we have multiple branches representing different sections of the membership within those facilities. This proposal would just simply require a bulletin board to be made available for each branch. So if you have 2 branches in there, you don't have to share one bulletin board. Each branch gets their own bulletin board. All right, next, uniforms, which is a huge topic of this round of collective bargaining. I don't have to explain to anyone that's watching this video what the problem is with uniforms. The system as it stands is broken. It's a system that does not allow letter carriers to get the adequate uniform items that we need. You know, Post Service, even from their perspective, you know, they know that long-term the model is going to cost them way more money than it should, and the result is honestly that letter carriers, because we're not able to get the uniform items, you know, very often have difficulty being outfitted completely in uniforms every day. So that's a huge piece of it. This particular proposal I'm going to mention is a little more narrow, but I think reflects one of the problems that's out there with the uniform program. So the Employee Labor Relations Manual in Chapter 9, Section 934, talks about uniforms, and there's a particular section about seasonal changes in uniforms. There's a lot of new letter carriers out there that if local management where you work is not a stickler for this kind of thing, you know, you may not even be aware of this. But there are certain things that are required there during certain periods of the year. For example, things when you wear a long sleeve shirt and with socks and stuff like that in the winter. This proposal is simply just to exempt letter carriers from those seasonal changes of uniform. I mean, in many ways it's outdated. Frankly, a lot of the items that our vendors produce these days, you very rarely see letter carriers wear or utilize, and that kind of builds cost into the system. And plus, you know, it's just simply annoying for us to, at a time when we can't, with the allowance we have, buy adequate uniform items in a lot of cases, for us to also have this obligation that during certain seasons to wear different things. So it's just a common sense approach, we believe. Next, we go to Article 28, which is employer claims. If you recall, if you watched the first video, I talked about some Postal Service proposals related to Article 28, where they wanted to increase they wanted to change the language about, you know, kind of the threshold for them being able to hold an employee accountable. Article 27 is employee claims, where we lose something as a result of work, and the Post Service wanted to increase the minimums before we could file such a claim. This proposal is Article 28, employer claims, and it's basically about, in the event the Postal Service files an employer claim and tries to collect from a letter carrier, adding language here would be just a brand new section, Section C, that, you know, any demand that's made from an employer, in other words, if they try to initiate an employer claim 1 year or more after the incident that they are claiming, that it would be considered, the debt would be considered waived. So effectively placing a statute of limitations of sorts on employer claims of 1 year. And this is designed to just prevent, years down the road, a manager trying to, hold an employee accountable for something where, honestly, anything that legitimately rises to the level of the employee, the test of we have to show willful disregard, so effectively do something intentionally, that's going to be known immediately. So any legitimate employer claim, of which there's not often legitimate ones, but in the event there is something that would be known quickly, and placing a time limit on it is what we are proposing here. Okay, next, back to Article 41, Section 3. Now we're going down to Article 41 and adding a new section that would be 3T. And this is also about breaks, kind of going back to the break locations that currently have to be authorized, back to the 1564A, that's the form that's in our route book. This is new language that we would put here that effectively says letter carriers can take a street break at any point they want during the performance of their duties, and that's at the carrier's discretion. It doesn't require prior authorization for a break location. Okay, next, let's go to Article 12, Section 1D. Very often, we think of Article 12 about accessing and withholding and accessing, but this proposal is about rehired employees. And Article 12, Section 1 deals with a lot of principles of seniority, and this is a proposal that employees that are rehired, if they had previously completed a probationary period, that when they're rehired, they do not have to complete that probationary period again. Okay, next, Article 7, Section 1C4. There is language here. This has to do with what the Postal Service's obligation is for making every effort to give straight time hours to PTFs prior to giving them to CCAs. This language has been around a long time. We had basically the same language when we had TEs prior to CCAs. What this language, the change that we propose here, doesn't change that obligation, but it does create an additional obligation for those that are temporarily assigned CCAs or PTFs to work outside their home office. So it would require management in the gaining office, if we call it that, to utilize the PTF CCAs up to the maximum at the straight time rate before bringing an employee in from another office temporarily. Okay, a couple of Article 8 things. We'll go to Article 8, Section 3, and CCA and PTF hours. We have a step forward from years ago with PTFs that says, there's no contractual requirement for management to equitably distribute or equalize PTF hours, but they should continue to make every effort to do so. What we're proposing here is language in Article 8, Section 3 that would really create an equitability for PTFs and CCAs, so that the work that they performed over the course of a quarter, the hours worked and the opportunities, would have to be tracked, and that they should be distributed equitably. Effectively using the same principles that we've used for overtime equitability for those that are on the overtime desired list, and applying that to the hours worked by CCAs and PTFs. Next, Article 8, Section 6 with CCAs. This is a proposal that would require the Postal Service to pay CCAs Sunday premium for work that they perform on a Sunday. A couple MOUs here. One, the clarification of regulations for the National Day of Observance. Easiest way for me to explain this that most people would be familiar with, at least the last half dozen or so national days of observance that we've had have been the deaths of former presidents, where then the president would declare a day as a national day of observance, and Postal Service has historically observed those. This proposal for us would be to take that MOU and add CCAs so that CCAs would receive administrative leave on a national day of observance. Next is modification to the MOU about PTF court leave, and simply would provide court leave, just as is provided to PTFs, to CCAs after the completion of their initial 90 workday or 120-day period of employment. Similarly, the MOU on paid military leave, this proposal would add CCAs so that they would also receive paid military leave. All right, another CCA one, back to Appendix B, which again comes from the DOS award. It includes a lot of different provisions that relate to CCAs. This one is specifically about Section B, and the proposal here is language that would state that CCAs that have absences of 3 workdays or less because of illness, that a supervisor can accept the employee's statement, explanation, basically as to why that they were out. As many shop stewards out there know, that type of language, while it's permissive in terms of what the supervisor can accept, we very often see issues with CCAs that call in sick and because they're ill, they can't come to work around a district, or maybe it's a POOM. There's some notice put out that CCAs or sometimes even beyond CCAs need to bring doctor's excuses for missing just 1 day of work, and this is language that would clear that up and follows effectively the pattern of the language that's currently in the Employee Labor Relations Manual that applies to career employees. Okay, next, opting, Article 41. This relates to Article 41, and this is intended to correct an inconsistency between PTFs and CCAs that honestly nobody ever really intended. So let me just explain a little bit of what the issue is here first. PTFs currently cannot opt until they complete their probationary period, which is 90 days. That's been the case for a long time, for decades now. When CCAs were created by the DOS award, the MOU that was in the DOS award about CCA opting stated that CCAs could opt after they had completed 60 days. So currently we have a situation where new PTFs are hired or someone's converted to PTF and they have to serve a probationary period. They cannot opt for 90 days, while CCAs that are newly hired can opt after just 60 days. What we are proposing here through this MOU is that the period, the waiting period, if you want to call it that, for both CCAs and PTFs would be 60 days. So we would change PTFs from having to complete their probationary period, the 90 days, to 60 days. Next, Article 25, a real simple proposal here that would just apply Article 25 to CCAs. There's a lot of impacts, or maybe not a lot, but several positive impacts on CCAs. Maybe the most notable one would be that CCAs could then use their relative standing to select temporarily vacant care technician positions. They currently do not have the ability to do that. It also would trigger the mechanism for paying CCAs higher level that do select those or are assigned by management to one that requires them to be paid like care technicians, would be simplified and be the same as PTFs. Currently, it's a little bit of a manual process and having to change their occupational codes and things like that. Okay, next is a proposal for another very little used or discussed article, and that's Article 20 about employee parking. And our proposal here is in Section 4 that would create a requirement for the Postal Service to provide on-site parking for each city letter carrier employed, at each facility around the country. I mentioned in the opening, that a lot of these proposals are still sort of under discussion. In any round of bargaining, there's things that each side proposes and the other side kind of immediately says no to. Just be real honest about this one. The Postal Service doesn't have any interest in this. Those of you that work in, a lot of our larger cities know that it's something that literally would be almost impossible to do just because of space in some locations. So I think that proposal as written, I know the Postal Service doesn't have any interest in it, doesn't mean we can't continue to pursue improvements in terms of parking that would be provided. Okay, next we'll go to Article 8. I know, again, in the last video we talked about some of the Article 8 changes that we were working on, the significant ones. But a couple more here related to Article 8. One is a letter of intent is the form in which we proposed a change or clarification of the MOU on signing overtime lists. So currently and have had for a number of years now, an MOU that gave the local parties, local management, the local branch the ability to develop a process that would allow those that are converted to full-time in the middle of a quarter or transfer in as full-time in the middle of a quarter to develop a process to let them sign the overtime desired list or the work assignment list. The proposal here is just to make that the way it is, that everybody that is converted in the middle of the quarter would have up to 2 weeks to make that decision to sign the overtime list or the work assignment list. Next, back to Article 8 again, Section 8. This is a section that includes in part work hour guarantees in different circumstances. The proposal here very simply would require a 4-hour guarantee for all employees regardless of the size of the office. Sometimes in certain size offices now it's 4 hours, in other offices it's 2 hours. So this would make it 4 hours everywhere. Okay, a few things here related to transfers. The first is a new MOU that we proposed on eReassign, the program that you go in and submit a transfer request and that the Postal Service uses in many ways to process and approve, deny, track transfer request and that entire transfer process. This is a change to the program that this MOU would state that a transfer request that's entered in eReassign remains active until it's either accepted or denied, or obviously the person that submitted it decides to rescind it, or if they've declined the opportunity. So as opposed to, having a expiration where you put one in and you got to renew it after X amount of time, it would just remain active until there was some sort of action on that request. Next is on the transfer MOU. This is also in Article 12, Section 6, the same language. It's an MOU that goes back a long time, goes back to the joint bargaining days, and MOU's been the same in at least our craft and the mail handlers and the clerk craft for a long time. The proposal here is to remove the geographical restrictions and the lock-in period when requesting a transfer. The primary reason for this is that the geographical piece of districts that are next to one another, the structure of the Postal Service district-wise has changed dramatically since this was put into effect. Basically, there used to be a whole lot more in terms of the number of districts than there are now. The lock-in period, we have issues there sometimes, particularly when a CCA converts and maybe has been a CCA for a period of time. They convert, then have to serve a lock-in period. So whether it's this proposal as we wrote it, or pursuing, something like utilizing CCA time to credit towards that lock-in period to help satisfy it, I think there's a number of possibilities we can keep pursuing. There. Next is an MOU that we have proposed about the health insurance coverage for non-careers, and this has to do with the extension of the coverage after converting to career. So currently, if someone's a CCA, they have the non-career health plan. When they convert to career, that health insurance will continue up to 30 days. That same employee, once converting to career, has a 60-day window to select a plan now in the Postal Service health benefits, a career plan, hopefully the NALC health benefit plan, because it's the best one. What this proposal would do is extend the period that the non-career health plan coverage continues from 30 days to 60 days. That way, you've got this 60-day window to select a career plan. You don't run into a situation where someone loses their non-career coverage after 30 days and they've not yet selected a career health insurance plan. So this would extend the non-career extended coverage from 30 days after they convert to 60 days to be consistent with that 60-day window for selecting a career plan. Next, an MOU about Act of God. Very simply, this would add CCAs to the Act of God provisions. This is when, an Act of God, typically weather, things like snowstorms, hurricanes, tornadoes, stuff like that, prevents letter carriers from being able to work. And we are paid administrative leave when that unfortunate circumstance happens. This MOU would include CCAs so that they too would be paid administrative leave. Next, another CCA proposal, an MOU about blood donation, would just make clear that CCAs are eligible for administrative leave when they make voluntary blood donation. This is kind of commonly referred to as blood leave. Career employees have that benefit, and it would extend that to CCAs. Okay, shifting gears a little bit here, a couple of things related to sick leave. The first is an MOU on restricted sick leave. There is, in the Employee Labor Relations Manual, there's a fairly detailed set of rules related to this program or process or concept of restricted sick leave. One thing that we've had a lot of problems with over the years is the Postal Service attempting to basically circumvent that and use what they call deems desirable. That, hey, we are going to effectively put you on restricted sick leave without calling it that, or we're going to request documentation for this and you only miss one day because we have decided, we have deemed desirable that we need to do that. What this MOU would do is, for this concept of deemed desirable, would apply all that language about restricted sick leave. So it would eliminate the Postal Service's attempts to use this deemed desirable concept that I know a lot of stewards out there are familiar with. They could still say that that's what we're doing here, but after this MOU, it would be subject to all the provisions related to restricted sick leave that currently exist in the Employee Labor Relations Manual. Next is an MOU about sick leave for dependent care. Currently, we are limited to 80 hours a year of sick leave for dependent care. The Family Medical Leave Act, of course, provides protection for up to 12 weeks or 480 hours for dependent care. But the law defaults to, in terms of the type of leave or the amount of leave, the law defaults to whatever the employer provides in terms of leave. So the FMLA guarantees you the protection of the time off, but defaults to what the employer provides as far as leave. Our proposal here is to increase that 80 hours of sick leave for dependent care to 480 hours a year. So FMLA protects you for 12 weeks, 480 hours, that we would be able to use sick leave if that FMLA covered absence was for dependent care. We'd be able to use up to 480 hours of sick leave. All right, next, an MOU about layoff protection. Article 6 of our agreement provides layoff protection currently to those that have 6 years of career service. And this MOU, the proposal from us, is that on the effective date of the contract, which likely is May 23rd, 2026, all those in the regular workforce at that time, even if they don't have 6 years of service, that they would be provided layoff protection. Okay, probationary period, back to Article 12. This is about CCAs that are and they're primarily about CCAs when they're converted to career. The language, basically says that any time spent as a letter carrier prior to conversion to career will be counted towards their probationary period. So basically, if you've worked 90 days as a city carrier, most commonly that's going to be as a CCA now. It could be, there's all sorts of unique circumstances that happen. But for the most part, we're talking about someone that's worked 90 days as a CCA. When you're converted to career, you would not serve a probationary period. You may recall originally, after the DOS award, it was someone had to work 2 full terms as a CCA before that probation was waived. Through a number of MOUs over the years that we worked on or negotiated, that went down to 1 year. This basically would say your probation is served as a CCA, and then when you're converted, you don't have an additional probation as long as you've completed 90 days. Next is another new MOU about temporary craft assignments, and this is mostly about DSIs, driver safety instructors. There's a lot of letter carriers that serve as what's called ad hoc DSIs. So they're still letter carriers. It's not their full-time job. They are just selected to perform this temporary craft assignment of being a driver safety instructor. This MOU would make clear that those that are placed in that position temporarily remain in NALC's pay tables. The full-time driver safety instructor job is a job represented by APWU. So you go into the clerk pay tables when you go into that on a full-time permanent basis. This is to ensure that our members that are placed in there on a temporary basis stay in our pay table, because being in our pay table is financially advantageous to them compared to being moved into the APWU pay table. Next, back to Article 2, Section 1. This is the article about non-discrimination and civil rights, and has protections for certain classes, and expresses really a principle of equality and non-discrimination. The proposal here is that we would add language that would include sexual orientation, gender identity, and gender expression as an affectional preference as protected classes that would also be included in those that are listed, along with race, creed, etc., in the existing language in Article 2. Okay, next to Article 7, back to Section 3, and this is language about combining craft work. It's, as many of you know that have dealt with cross-craft assignments, it can be a little bit complicated. But the piece that we're really talking about here is, in a sense, a maximization type of idea, that any unassigned city carrier work, which probably most common is an auxiliary route, but it could be lots of other things. You know, as our work continues to evolve, we don't, really know exactly what the future brings, but it's definitely a possibility that work could go beyond auxiliary routes. But this just explicitly would require the Postal Service to combine all the maximum number of all the unassigned work to create the maximum number of full-time assignments. It also would give the union the ability to request route inspections pursuant to Section 271, a handbook N39. This would specifically be 271 Section G for auxiliary routes. Okay, a few Article 8 things here. Multiple sections in Article 8 refer to the penalty exclusion period. The December period, our proposal here is real simple. Eliminate the penalty exclusion period that happens in December. To Article 8, Section 2, a proposal that would add the 11.5-hour and 60-hour limit and the protection from discipline if the employee chooses to leave and not volunteer to work over. The same language we incorporated for full-time employees not on the ODL in the 2023 agreement. This proposal would add those limits and that protection of discipline for CCAs and PTFs. Overtime pecking order. This is one that's been a common point of discussion in bargaining for a long time now. It's got to do with Article 8, Section 5, D and G. And the idea here is to create a pecking order. Currently, management has an obligation pursuant to Article 8, Section 5G to maximize full-time employees on the overtime desired list before requiring those that are not on the overtime desired list to work overtime. What we're proposing here is that they also would have to maximize CCAs and PTFs. And kind of the structure of how we presented this proposal is to create a pecking order similar to what we have for the letter carrier paragraph in the JCAM, if you see how it's laid out there. But simply put, maximize CCAs and PTFs along with those on the ODL before working those that are not on the ODL overtime. Okay, next an MOU regarding Article 15 and back pay specifically. One of the issues that we often have when a letter carrier is either suspended or is placed on removal, or we're successful in a grievance and they then are entitled to back pay, is a lot of inconsistency with the timing of the process of getting them paid back. And sometimes that is a result of a manager at the district level, a delay in their part of the processing. Sometimes we even see it with the accounting center up in Minnesota, though that's been less of an issue here recently. But what this proposal would do is put very strict timelines in place that, once back pay has as a result of a grievance settlement or an arbitration decision, the requirement for back pay starts. Management's got 7 days to provide the employee the form. They would then have 7 days after they receive the form back to handle their processing of the 8038 and the 8039. And then management would have 30 days to actually issue the back pay once all that processing is complete. It's just to put what we believe are very reasonable time limits to address what we view as unnecessary delays that happen pretty often. Next is a letter of intent, what we're calling leave restoration. So in the 2023 agreement, we, for the first time, achieved provisions that when letter carriers were placed on an Article 16, Section 7 suspension or emergency suspension, emergency placement is a common term that's used here, that employee at their option could use some annual leave so that they wouldn't suffer a loss in pay. Totally at the employee's option. What we are proposing here is that when a 16-7 suspension is rescinded or it's overturned, that any annual leave that was due to be restored. So if an employee uses some annual leave, the 16-7 is rescinded, they got to be made whole, they have to be given that leave back. That leave would be immediately made available to the employee. Next one, another simple, back to Article 16, Section 1. This is language that we're proposing that whenever possible, management would have to issue discipline notices to employees in person. But whenever possible, I mean, there are obviously circumstances where, employees are not at work for whatever reason. They may want to mail it to them. And the idea here is to avoid a circumstance where the letter carrier that they are issuing discipline to is there. They could simply provide them with the discipline, then they could give it to the union very quickly. Places where instead they choose to mail it, there's just no reason to do that. And this is really geared towards the timeliness of grievances and the timeliness, most importantly, of if we're successful in the grievance, getting it done as quickly as possible. So if the Postal Service is going to issue discipline, give it to them in person. All right, next is an MOU that would create a process for mutual exchanges for CCAs. We have a mutual exchange process for career employees that's been in place a long time. This would basically create the same process for CCAs. Okay, another CCA. What about CCA annual leave? Those of you that have been around for a little while and have been involved in local implementation or LMOU negotiations will remember that after the DAS award in 2013 and that round of local implementation, we had a number of issues with achieving and securing leave provisions in LMOUs for CCAs. We then clarified that language in the 2016 agreement, and a lot of locations in that round of local implementations, local negotiations did achieve that. But we still have places out there that do not have leave provisions in their LMOU for CCAs. It's just simply a proposal that says if that, in the absence of that language, that the parties will get together locally and incorporate language that would give CCAs annual leave provisions. Okay, next, back to Article 41. This has to do with 204Bs, which are the language that we're proposing here would appear in Article 41, Section 182. Very simply, it's just a restriction that says once the 2026 agreement is in effect, that temporary supervisors, craft employees that are serving as temporary supervisors may not supervise city carrier employees. Something on safety, specifically dog safety. We proposed an MOU that would put a program in place just more structured than what we currently have to prevent dog bites and also a more structured way of reporting dangerous animals that are out there. I don't have to explain to anyone the importance of that. A new MOU that we're proposing here about CCA voluntary reassignments or transfers, piloting an actual program that would allow them to transfer. Look, we've had an MOU for years and have discussed with the Postal Service pursuant to that MOU what a process like that would look like. Their resistance has been that they didn't want to put CCAs into the e-reassign program. And while that's not what's written in this MOU, because e-reassign might change next week to some other program, the idea here in this pilot would be to use the same processes that we use for career employees. Also in e-reassign, a new MOU regarding mutual exchanges that applies to current mutual exchanges for career employees, and that is to incorporate a dedicated process within the e-reassign program to look for, select, apply for mutual exchanges. That doesn't exist currently, and of course, the mutual exchange ads in the Postal Record are, have at this point, who knows how many thousands and thousands of success stories over the years, but there's really not a way utilizing the technology that the Post Service has available that employees all have access to find other avenues of finding someone to exchange with where there's a mutual interest, and we think that e-reassign would be the best place to do that. Next, this might be a record in contract negotiations for the number of proposals related to Article 4 about technology and mechanization. This is also similar to what I talked about earlier with the proposal to have a kind of labor management committee that's pretty general, that would cover all sorts of things with technology. This is one that's specific to artificial intelligence, AI, that we would include have a joint labor management committee that would be focused specifically on the use of or potential implementation of artificial intelligence. Okay, next, something to do with Carrier Academy. What we want to do in this proposal, what we propose is a requirement that when new letter carriers are hired, that they would complete the Carrier Academy, the standard training program for city letter carriers is the official title of it, but that it would be completed within 30 days of when they are hired. And the proposal would be to put language in Article 8, Section 2 to do just that. Next, another MOU that's kind of related to some of the Article 8 stuff and also Article 11 that we talked about earlier on. And it's got to do with annual leave in conjunction with a holiday, which often impacts scheduling, the most immediate thing, but has a lot of sort of domino effects related to all sorts of things, from the Article 8 portion of the scheduling to the Article 11 portion of the scheduling to the Article 8 implications that happen, whether that's on a daily basis, on the holiday after 8 hours, or equitability, and then you've got people that have planned leave, and it's something that is often a point of contention. And what we're proposing here is an MOU that just simplifies it and makes it clear that city carriers that have annual leave scheduled, covering either their entire shift or their work hour guarantee, whichever is less, immediately before or after a holiday will not be required to work the holiday or designated holiday. So someone that has scheduled a full day of annual leave, or in the case of a PTF, maybe it could be less than a full day, because maybe they were not scheduled to work a full 8 hours. But that was scheduled and approved in conjunction with a holiday, they essentially are removed from the equation of holiday scheduling. This happens a lot of places already, but it's also a point of contention. Of course, the idea here is to allow those that to utilize annual leave by their seniority in conjunction with a holiday, not solely for the fact of getting out of work in the holiday, but to just be clear everywhere that we have a uniform application of annual leave in conjunction with a holiday. Next, this is an improvement, a change to an existing provision that we negotiated in the last agreement in Article 26, Section 2B. For the first time, we negotiated a process to have the uniform allowance that is unused carry over to the next year, fully realizing that there's not a whole lot of letter carriers that don't use their entire allowance these days, but this type of of change is something that we negotiated not just for the short term, but the long term. Currently, the way that it's applied, it's effectively delayed by a year. So allowance is carried over from one year to the other, but then you're not able to use it until the following year. This would make it immediately available in the year after without having to wait another year. Another uniform proposal is an MOU that we propose to create a program for maternity uniforms, that we would have a program to provide letter carrier uniforms, appropriate uniform items to pregnant letter carriers during their period of maternity. We're getting close to the end here. Next is an MOU regarding Form 3999s when managers go out with letter carriers and conduct a 3999. This MOU would require them to provide a one-day notice prior to conducting that 3999, very similarly to the requirement they have prior to conducting an office count of mail. All right, next one that'll probably resonate with almost, if not everyone watching this, and it has to do with personal headphones. There's been a restriction for a long time, with letter carriers wearing headphones. What we proposed here is that we would allow, employees would be allowed to use a single earbud, or those that have the pass-through technology transparency that so many of us are used to, that you can hear when they're not driving a vehicle. The reason for the restriction from a safety standpoint for a long time has been obviously that it impacts your hearing and awareness around you, but now with the ability to maybe just have one, or certainly with a transparency mode, we think that safety issue, when not operating a vehicle, is not as big of an issue anymore given that technology. So this is a proposal to allow that to happen. An MOU that would, or modifying the existing MOU on the new employee experience, retention, and mentoring program. This is an MOU that we first put into the last agreement after piloting it and testing it for quite a while before that. We are kind of simply looking, based on the experience that we've had so far, at a number of changes. It's something that's really just incorporating things that we've learned. We're not talking about massive changes and overhauling a lot of the specific provisions related to that. Last, certainly not least, is a proposal that we've had for a number of years, and that is that our heat illness prevention program, the HIP, an MOU that we have put forward that would require us to jointly modify and establish a heat illness prevention program that includes all of the things that are recommended, such as acclimatization and water and a work-rest regimen and training, et cetera, by the experts to keep letter carriers safe from the hazards of excessive heat. So I know that's a lot. That's a lot of proposals. A lot of these proposals we are still discussing, and some are kind of in the process of being modified based on counter proposals from the Postal Service, and then counter proposals to their counter proposals, and back and forth. And that'll continue as we work through this mediation period. We have, as I said, the collective bargaining conference upcoming here in just this upcoming week, and we will take the opportunity to talk about all these proposals and a whole lot more at that conference. So, as things continue to progress during that conference, following the conference, throughout this mediation period, we'll continue to keep everyone updated. We just really wanted to go through each and every one of them so everyone would know exactly what was put on the table. But once again, I think it's important to understand that through the negotiations process, there's some of this stuff we'll likely achieve, some of it will be modified, some of it, we won't achieve. That's just the nature of it. But for us in conducting the negotiations, all the information that was gathered from the participation of all our members through polls and surveys and at our National Rap Session, our Rank and File Committee members, and all the pieces that went into the preparation helps us develop these. It also helps us prioritize different pieces as we move forward. So we feel like we have a good sense of the things, of course, that are most important. Obviously, the economics being number one, but in terms of all these proposals I've talked about, the things that affect us every day. A lot of the Article 8 stuff, and certainly there's a number of other ones that I mentioned. Parental leave, for example, is another one that's really high on our list of priorities. So our work will continue. I appreciate everyone for tuning in to this lengthy update. We'll have a lot more coming up here in the future.
Well, no, I certainly appreciated that update there. That was excellent information. I think some of it was good. Some of it was pertaining to our CCAs, which is fine. But there's a lot of stuff. I know I in particularly enjoyed. What did I enjoy? I took down a lot of notes for this one. I certainly enjoyed the 12 weeks paternity paid leave. I thought that's a good one. Also, I enjoyed, let's see here as I get back on the screen here, as I enjoyed the bereavement leave, having that moved from 3 days to 5 days, and also extending out the family members who will be included in that. So that's certainly something that I enjoyed with that. What else? What else we got going on? So Article 16 changes with that. My camera looks just off. This just does not look right at all. I'm trying to figure this thing out. But it looks bad. Let me see here. But anyway, just a lot of different things on here. I do like how you get an additional break for overtime. If you work overtime, you get an extra break. I like some of the changes they're proposing about taking your breaks and lunch at any time, and also eliminating that travel time to and from. Once you get to your spot, your time starts, and then other things, moving back, there's no travel time restrictions. I do like that proposal as well. Let's see here if I can read my handwriting. Also, again, taking the lunch and breaks in any place you want to, with the scanning device and whatnot, the REMs, and they know where we're at anyway. Theoretically, I mean, that's the sole disciplinary measure, which they again adding that to this too. The scanner data, none of that can be the sole means of discipline. So I like that. I like how I don't have any discipline on my record, but to remove the discipline from the record from 2 years down to 1 year. Let's see here. What else do we have here? I took so many notes here. It's just a lot. I do like this article 15.4, where they want to try to limit what management does to try to delay grievances. They try to bifurcation there. In other words, to delay talking points. No, to get it done right away. Get it done that day. Let's see here. There's a couple other things too. Oh, I particularly like where it says here about the uniforms. We know the uniform allotment is broken. Uniform system is broken. So I do like these work on the article about seasonal changes, where you don't have to wear a specific thing, a specific item, because we know, you try to get some postal gear, that sweater, $100, and we can go down to the Target and get a hoodie, a blue hoodie that matches for like $40, $30. So what's the point? I do like those changes. A lot of changes again for the CCAs. I know they're trying. He said they're trying to eliminate that CCA class. They never should have agreed to it to begin with. Back when Rolando and Renfro years ago, they should have just never agreed to the CCA classification. But it's funny. It's funny how when it comes to comparability, UPS is doing something similar to that, having these unpaid people. And yeah, the post office readily agrees to that. But when it comes to pay comparability, nah, we ain't doing that. So that's funny. And of course, that's what they're going to do. They're a business, or we're not a business, but they think it's a business, and they're going to make the business decision. They're going to say, well, we're going to do what's best for our pocketbook. So that was a couple things with that. So I mentioned 204Bs, craft employees cannot supervise city carriers. How many times you get people up in there, they had no idea how to deal with the city side. Layoff protection. I like this for all carriers now. Once this contract goes through, if this passes, everyone who's hired as of May 23rd, 2026, will be protected from layoffs. This is a proposal I actually sent to them about AI. I'm glad they mentioned that towards the end of the day. At the end of this, that AI, all this technology and things that we can't be replaced or anything with that. Get some language in there to protect future jobs from that. And it's good to have this no layoff clause in there now, especially with this administration and possibly even future ones, especially as they want to try to move us from Article 1 protections to Article 2, putting us under the executive branch. And if we're under the executive, well, we can get fired because now we're under the president. So which is why we should reject any calls to be under the Chamber of Commerce or anything like that, because that's the executive. They can just fire us. Boom, bam, done with that. So lot of different things here that was proposed, and I do apologize here. I'm trying to get better with the streaming and stuff. I'm not the best at this. As I said, I'm 46 years old and got this technology and stuff, and I grew up with it. But these OBS hardware, software, and switching screens and all this, I'm gonna get there. But if you're with me now, stay with me throughout the years as we build this thing up and improve this platform, the Fighting Carrier. So I hope you guys enjoyed this nice long hour-and-a-half stream here. Hope you learned something. Rewind the video to re-listen to what was proposed, what was said here. There's many good things here that I enjoyed. So right now it's 9:30. I know some of you guys it's 10:30 out east. You got work tomorrow. I got work tomorrow as well. So I want to sign off right now. Eat some dinner. So I apologize for the noise too. My family, they forgot I was streaming, so some noise happened up and down. But it is what it is. I got to put a sign up on my door. It says currently streaming. Let's keep it down. Something like that. But all right, my name is Deshaun Bradley. This is the Fighting Carrier. Signing off, and hopefully I can break down some more of what Renfro said tonight, this week. Of course, I'm going to listen to it again and write stuff in my blogs, just some key points from it. So, signing off. I will catch you tomorrow when I'm back here around 7 o'clock Central Time. 7 o'clock Central Time. Deshaun Bradley here, signing